Hey, good morning, everyone. Welcome back to Law and Legitimacy. We had a little bit of a techno glitch right at 8 o'clock. I'm remain in the deep state, in the swamp here in D.C., and we were yapping away, getting ready to hit the on button when all of a sudden my thing said, "You lost your internet connection." And I checked my machine. It was there. So I rebooted. Who knows? I'll stay on until Uncle Sam turns me off. On that topic, just as we were getting ready to, just after we got off the air yesterday, I got an email from court saying, hey, due to an emergency, unforeseen emergency, sentencings in the Proud Boys cases are not going to take place today, and we're all going to be backed up a day. And after a busy morning of negotiations, the sentencing schedule got readjusted. So I was hoping not to go first with my clients, Joe Biggs and Zach Rell. I wanted to see what the court was going to do to some of the others before I got up and had to make my pitch for justice. But as luck would have it, I'm now going to go first and second. We'll start with sentencing of, Joe Biggs in a couple hours at 10 a.m. Eastern time. And then we'll move to Zach Rell at 2 p.m. Eastern time tomorrow. Dominic Pizzola will be sentenced at 10 a.m. Ethan Nordine at 2. And then on Tuesday, the president of the Proud Boys, Enrique Tarrio, will be.
Yeah, that was the curious thing. I think I sent you a text and I asked because previously Enrique Tarrio was scheduled to go first, right? So that was what I think a lot of people were anticipating yesterday, was that he would, his sentencing was gonna happen first of the 4 or 5 there, and then now he has been scheduled to September 5th.
Yeah, and I saw a lot of online chatter about that. One person's like, "Of course, he's cooperating with the government. They're going to milk him for all he's worth before he's sentenced." Give a person half a fact and they can make up a whole story. Enrique is not a cooperator with the government. What had happened is, 8:38 is when we got the note, and by 9:15, people were taking their postures. Enrique's lawyers needed to get back to Miami. They wanted to come back next week, and that's what happened. They had other court commitments, and so I don't know who had an emergency in the court system yesterday. I don't know what it's about. All I know is what I was told, that we were unable to go forward yesterday. And, candidly, in the 4.5 months we went to trial, that happened once before. So I don't attribute any significance to this event at all. I don't think anybody knew the lawyers' schedules. There's no secret machinations going on. And much though I love a conspiracy theory, I don't think there is a conspiracy afoot here. I think it's just ordinary human chaos. But I do expect trouble coming. I looked through, obviously, all the sentencing material yesterday. Again, and the government really insists that these guys, meaning Joe Biggs and Rell and the others, get sentences in the 30-year range. We think something far, far less is appropriate, and we'll put it before the court this morning. And Judge Kelly will make a decision. I will say this much. I will end on the following note in my remarks, and that is, one function of sentencing is to promote respect for the law. And as we await the court sentencing, I can't help but feel as I did in '93, looking at the standoff in Waco. How would this event end? I never foresaw that it would end with the storming of the place, the razing of the building, and 83 people dead. And the consequence of that was not to promote respect for the law, but if anything, to deepen cynicism about the federal government and its role and purpose in our life. Judge Kelly will have an opportunity to do justice today. Yes, some laws were broken, but the men aren't terrorists, and the notion that they need decades behind bars, in my view, is an insult to justice. But my view is just one of many. I'll be giving it on my feet in court, not once today, but twice, first in the morning as to Joe, and then in the afternoon as to Zach. Judge Kelly will rule, and the rest of us will deal with the consequences. So stay tuned, and, before, I'm sure it'll be all over the papers, whatever happens today, before you come back to Law and Legitimacy tomorrow morning. But I know you'll come back to Law and Legitimacy tomorrow morning to get the Insider's edition. So what do you want to hop? We got plenty going on. Where do you want to go next, Mike?
Well, we started yesterday. Let's do the Bailey v. Isles case out of the Fifth Circuit. Want to move to that? So the Bailey v. Isles case. This was a case that I didn't realize until even I think later yesterday, that was brought by the fire organization. And you'll have to excuse me because I'm kind of blanking on what that might mean. But Bailey v. Isles was a First Amendment case, or it is a First Amendment case, and this, the Fifth Circuit ruled on this just several days ago, last week, and it started with the arrest. Well, the basis for the case was the arrest of one Waylon Bailey, the petitioner in the case, and his subsequent charges related to domestic terrorism. So
yeah, and to me that's just crazy, because basically what he did is he posted something online in the heat of COVIDtopia saying, hey, you're going to be shot on sight if you don't get the vaccine, by the local police department. And on the strength of that communication, there it is online. Just in, Rapids Parish Sheriff's Office has issued the order. If deputies come into contact with the infected, shoot on sight. Lord have mercy on us all. Hashtag COVID something. I can't read that.
COVID-19 hashtag we need you, Brad Pitt.
And that obviously referring to one of the zombie movies where Brad was shooting at the zombies. And so, if any utterance could be taken as on its face is sort of ironic, playful, maybe juvenile, maybe not even constructive, but protected speech, this is it. And so how is it that the sheriff's department justified searching and conducting an arrest in this case? Mike, what was their claim?
Well, before we go on, I just further context here. I've got that on the screen as well. So it says Bailey's post was in response to another friend, Matthew Mertens, posting a joke about COVID, and Mertens understood Bailey's post to be a joke. The two continued to post comments underneath Bailey's post. Mertens posted, quote, LOL, and he, referring to Bailey, talking about my post going to get flagged, and then he put the crying, laughing emoji. He wins. Bailey posted, quote, this is your fault, and, quote, you made me do this. Another person who Mertens later identified as Bailey's wife also jokingly commented, quote, I'm reporting you. So it's even more absurd just than we thought on the face of the screenshot above with that one post with the hashtag, we need you, Brad Pitt. It was, if any functioning person reading this could see this thread, it's obviously a joke. It is most obviously a joke. And I guess the real joke was the law enforcement response. So law enforcement responds, he's arrested, and then the basis of this case is ultimately, and Norm, you can take me through the exceptions to the First Amendment. What are there, 5? So the First Amendment guarantees free speech, right? 14th Amendment incorporates that Bill of Rights to the states, giving, an individual in a given state an action under the Constitution. But what are those 5 exceptions to the First Amendment guarantee of free speech, Norm? Do you know?
I don't know if there are 5, but you can't defame someone. You can't engage in a true threat. You can't incite to commit violence. You can't you can't express yourself pornographically or engage in obscenity. And you can't, and to make it a 5th, you can't engage in speech that otherwise is conspiracy or planning to commit a crime. So while the First Amendment says Congress shall make no law abridging freedom of speech, we do have laws abridging freedom of speech. And so tort law imposes some limit. In the area of true threats, there's a rapidly developing body of law in the Supreme Court, including most recently in June of this past year, the Counterman decision, that talks about a true threat. And a true threat is something that creates an imminent risk of or fear, an imminent and reasonable fear in the mind of another, that they are about ready to become subject to violence. And the utterer, the person who speaks it, has to be aware of the risk of that harm to another person. So in this case, I think police officers viewed this as a true threat, or maybe an incitement to others, because their fear was that when others saw police coming now, believing that police would be prepared to shoot, perhaps, they might shoot back. And that's the sort of abstract, attenuated reasoning that courts show disdain for in every occasion. Now, what had happened in the trial court level, he sued in part for, Bailey sued in part for an abridgment of his First Amendment rights, in part for that he was arrested without probable cause. That is,
there's also a qualified immunity angle to this as well. Right?
And so the trial court granted qualified immunity, basically saying, there was no case directly on point, and therefore, the officer's conduct wasn't against clearly established law. The Fifth Circuit said, wait a minute, people, grow the F up. There are times when things are just patently so obviously protected, you don't need a case to tell you that. And so the Fifth Circuit reversed the trial court judge. I don't know whether the defendants will go to the United States Supreme Court. You know, qualified immunity is an issue that the Supreme Court is interested in. I know my office is prepared at the end of September to file a writ. We're trying to get qualified immunity and whether it's constitutional and whether it's an abridgment of a Seventh Amendment right to a jury trial. We're trying to get the court to bite on that issue in an unrelated case. But Bailey might be another occasion to bring that up. But I think the Fifth Circuit got it right. I think that the trial court was dead wrong. Qualified immunity keeps public officials from being accounted to those whom they govern, and courts ought to be open for these disputes. Qualified immunity is a legal doctrine in the court's view, protects police officers from all but the plainly incompetent, or protects all but the plainly incompetent from having to spend the time and effort to defend themselves from civil suits. I get the feeling of necessity to protect law enforcement officers from frivolous suits, but granting them immunity from acts like this, like the arrest of Mr. Bailey, is just dead wrong. It encourages them to police speech more aggressively. It encourages them to criminalize speech that they disagree with. And the whole point of having a First Amendment is to protect robust speech, including critical and satirical takedowns of government.
That's right. And while we have just a moment here, I'm putting on the screen, I just wanted to recognize In the Cloud, thank you for the $10 tip over on Rumble. And In the Cloud says, hoping for the best case scenario, Norm. So again, thank you In the Cloud for the tip. And Norm, I just wanted to share that with you so you could see the note.
Thanks. Yeah, no, but we, me too. Me too. In the Cloud. Thank you very much. I'm assuming you're referring, obviously, to the Proud Boys case.
The Proud Boys stuff. Yeah. So this stuff was the getting back to Bailey. This is interesting because the way that Fire describes this, I'm just going to read the paragraph here in the middle of their case overview because I think it helps quite a lot with this. But it says, when Bailey brought a civil rights lawsuit against the arresting detective and sheriff, the judge erroneously granted the officers qualified immunity by applying a long since discredited legal standard to conclude that Bailey's obvious joke on Facebook was not protected speech. The court applied the now 100-year-old clear and present danger test from Schenck v. United States to wrongly conclude Bailey's speech was beyond the reach of the First Amendment because of its serious implications in light of the pandemic. This reasoning ignores the clearly established protections for humor in the First Amendment and puts millions of present and future speakers in jeopardy of criminal sanctions. I just think that it's amazing because they also described that it was a fully armed SWAT team and a detective that made the arrest of Bailey subsequent to this post. And so when we put all of that stuff in context, it's just, I mean, I don't understand at all, seriously, at all, how this could have been something that took place and no one within the chain of command within law enforcement had the wherewithal to say, hey, this isn't something that we should be playing with.
Well, it's scary. It's scary stuff. And, the clear and present danger test comes out of the Abrams decision and the Schenck decision. And it basically says, that you can't fire, it's an old decision that has never been explicitly overruled. In other words, no one has ever said this decision is wrong, but the law has evolved beyond it. And so you can't, in that case, shout fire in a crowded theater because of the clear and present danger that it would create harm to others. The court has evolved beyond that test, and no serious constitutional lawyer applies it, which makes me wonder, who's the box of rocks sitting on the bench?
That's exactly right. That's exactly right. And this is one of the most
common. Mitch McConnell's brother. I mean, sort of aged out and just not on the bench, but in spirit, but in body only.
Well, maybe if you hang out in the corners of law Twitter long enough, you'll definitely get this sort of fire in a crowded theater BS back and forth, right in your timeline. But for those of you listening who might have come across some sort of back and forth over the clear and present danger or the quote unquote fire in a crowded theater, like proposed exception to the First Amendment, and then you see somebody saying, hey, that's long since been overruled or that's not the law. Norm just gave you all the insight you need to understand why someone's saying you can't yell fire in a crowded theater as some sort of potential exception to First Amendment protection. It's just and law students should know that as well, right? So we've evolved past that test.
Oh, and by the way, on the topic of law students, those of you who went ahead and purchased the con law book I talked about last week, don't be discouraged. We will return to it next week. I just didn't want to take all 6 pounds of the book with me down to DC, and so get prepared for discussion number 2, which will be on the structure of federalism and separation of powers. We'll resume with that next week, and we'll begin going through that book a couple assignments at a time each week, and we will get through it within the course of an academic year. So those of you who are interested in an overview of constitutional law, at least from the eyes of a couple practitioners, stay tuned and keep up your reading. I'm thinking of you, Lawyer Will.
Yeah, Lawyer Will just hopped in the chat here. I was about to read something for you, but before that, Jackson Barrett says instantaneous mass communication converts the whole world into, quote, a crowded theater. Fair point.
Actually, yeah.
And then that is, and then of course, top down social media responses have been what is it? Freedom of speech, but not freedom of reach. And then we've got the new CEO of Twitter saying lawful but not awful, or awful but lawful kind of stuff as a justification for shadow banning and slowing down the ability for speakers and content creators on that platform, on X, to actually reach larger audiences. So we have just described the entire, I guess, the broad landscape of speech online in modern America and abroad. Lawyer Will says, have we talked about Giuliani being defaulted in his defamation case because of discovery issues? It's like the Alex Jones case. No, we have not, and we will probably talk about that tomorrow, I imagine. Norm, you definitely posted about that yesterday on X. I think you said Alex Jones redo when you were
Redux, yeah,
Redux, quoting an article that was
talking. I'm not sure there's a long discussion that needs to be had about it, Mike. Maybe we can just knock it off right now. I mean, Giuliani didn't, if you're sued civilly and you've got discovery responses, somebody serves interrogatories on you, that is, requests that you respond under oath to certain questions, or requests for productions that you produce things, you got to comply. It may be onerous, it may be a pain in the neck, but if you don't comply, you die, you get a default. And if your compliance is unsatisfactory, you might get defaulted. And a default means you lose the ability to defend on the merits. A trial court judge made that decision as to Alex Jones. We think she's wrong. We've taken an appeal. I'm not exactly sure how bad it was with Rudy. If he ignored the suit altogether, he's got a default coming. If his discovery compliance was not satisfactory to the plaintiffs, then of course you have to wonder about litigation gamesmanship and whether they're trying to avoid trying a difficult case by relying on a procedural trick. We will look into that and report more. So, thanks for the tip, Lawyer Will. Discovery defaults are not common, and I don't think they should be a common tool. I think the way to deal with that is if a person doesn't adequately comply, give a spoliation charge to the jury. In other words, the person didn't preserve evidence they were entitled to preserve, or let the jury draw an adverse inference. But taking a jury's right to make a decision away, taking a defendant's right to have that jury make a decision is difficult. Where's Ronald Reagan when we need him? I think Ronald Reagan has gone the way of all flesh, folks. We'll be joining him soon. We need new politicians. We need a new class of leadership, and we're trying to cultivate them here on Law and Legitimacy. But Mike, what's up with the UAW?
I was just really interested to talk about this because of the accidental discovery I think I made that sort of that brings more politics into the fold, but in particular the Biden administration. So this is from the New York Sun. Norm, you turned me on to the New York Sun yesterday, saying that you had been made aware that there was a sort of a revival effort underway with a pretty old publication. I'm not aware of how old the New York Sun is. I remember seeing this, growing up. I think the brand. But if there is a revival effort or a renaissance of this paper, it seems to be mostly moderate. Just looking at the homepage this morning, which I think is a positive sign for those of us looking for, more major media outlets with reach that are not going to slant one way too hard or the other. But this was on the page this morning, and it struck me because of our focus on the environmental, social governance, and diversity, equity, and inclusion in the context of the current presidential administration and the way that corporate America has seemed to align itself with a lot of that, along with the top level finance side of things. So UAW is United Auto Workers. It's a major auto union. It's the union that is attendant to the big three automakers in America. So we've got General Motors, we have Ford, and I think what is the third one now called? That starts with an S. Maybe it's
I don't remember.
Yeah, Stellantis. So the reason you're seeing a lot of the dumb Alfa Romeo vehicles and stuff like that, is due to that. They own that brand as well as Dodge and the rest of those, not under the GM and Ford umbrellas. But right now, I think September 14th is a deadline by which the union, UAW, and those big three need to come to a deal on union compensation, so union employee compensation. And if they don't, they're threatening a strike. But the core issue right now, as I will just highlight here in the article itself, is that the Biden administration has a goal of decarbonizing the economy by 2050 and pushing the American auto industry to accelerate the transition to electric vehicles. And you might be asking, well, what does this have to do with the labor? Well, a lot, apparently, right? Making an electric vehicle is not at all like manufacturing an electric vehicle, and there is a ton of uncertainty around the value of labor as well as the security of the labor force. UAW, as I understand it, represents over 400,000 union members. Right?
And existing contracts, I mean, for example, parts and supplies. So, UAW are auto workers. They assemble automobiles. If you're going to assemble, and these are gas propelled automobiles. If you're going to switch to electronic vehicles, it's going to require different components, and manufacturers may be able to escape existing contracts by purchasing the parts for the electronic vehicles, batteries, for example, from non-unionized employees. So the UAW's position is, wait a minute, we have a collective bargaining agreement to produce an essential component of the American economy. And if the government is trying to compel us or is trying to force the industry in a different direction, it may be forcing us into new contracts, and it may be forcing us to use or maybe empowering manufacturers to use labor that is not bargained for. And I think one of the things that gets a lot of UAW people pissed off about this is right now the UAW is basically operating under federal oversight anyhow.
That's exactly right. So this is where, this is what makes this a story for us, I think, Norm, is that toward the bottom of this Sun article, it talks about the fact that the United Auto Workers leadership has withheld their re-election endorsement for Mr. Biden until the union's concerns about the auto industry's transition to electric vehicles are addressed. Which means what? That, if they've withheld an endorsement for him for re-election, did they endorse him the first time around? And yes, as we can see here in this Reuters article from April of 2020, UAW in 2020 pledged their support for one Joe Biden.
What were they thinking?
Over one Donald Trump. And that was my question. It doesn't even seem rational for that to have been the case. Biden was already talking about this ESG platform throughout his campaign, right? He wasn't active on the trail, but this was a pretty big deal when an auto workers union with 400,000 members plus pledges its support for a president whose administration was going to fundamentally change the landscape and the field of commerce, the stream of commerce for the industry that they apply their labor to. So I thought that was curious. But then we learn also, Norm, that in and among the things going on in 2020 was an investigation into the UAW by the DOJ. And that investigation was happening sometime around June. And then, I guess the investigation started earlier in the year. Then the UAW pledged its support for Biden's reelection or Biden's election. Biden was elected, and excuse me, I'm not trying to piss anybody off. Biden is elected, and then shortly after that election in November, we see this settlement agreement in December, with the
No,
UAW.
and read it. I mean, you don't need to read the story carefully, folks. Take our word for it at this point, but read it at your leisure. But it's a very unusual filing. The suit was filed, and the same day the suit was filed, a settlement was reached,
That's
and
right.
the settlement was filed, and that settlement required a federal oversight of the UAW for a period of 6 years. In other words, it's not quite a receiver, but there's a trustee in place that takes a look at operations of the UAW and has the ability to refer United Auto Workers members to a union tribunal for discipline.
So it's a
while
6-year monitor. Get this. It's a 6-year monitor of UAW. And then also, this is, I think, what I sent to you, Norm. It says, besides the monitor, the UAW will conduct a binding and secret ballot referendum of its membership, overseen by the monitor and the Department of Labor, to determine whether to change the UAW's election method from the current delegate system to a direct election model, where the entire UAW membership could vote for the UAW president and the other members of the UAW's International Executive Board.
So what is the United States government doing, telling a union how to operate itself? And what kind of negotiations were going on when the UAW decided to endorse Joe Biden? And how is it that just after the election, the lawsuit got filed and settled on the same day? And now is it the case that the UAW members are saying, wait a minute, we've been taken over by the feds and we're being led to slaughter in the name of the public health state. And so now the monitor is telling us what to do, how to vote, but the president's telling us what we can manufacture. And maybe we're just supposed to sit back, sit on our hands and die a slow death while we all search for work at McDonald's.
That's exactly
and I
right.
think the UAW is pushing back. And I got a hunch that a lot of the members of the rank and file aren't going to be going Biden 2024. They may be looking elsewhere, and they may be looking in the direction of Donald Trump.
That's right. That's right. But ultimately, I think that I still have a question of whether this monitor is in place and what the results of this independent monitor has been. I'm also curious as to whether they have actually reformed their election system to that direct model. Again, that's 400,000 people, and if they already had a model,
400,000. Like, I grew up in Detroit, a heavily an auto worker city, and a union. These are union households. So for every auto worker, you've got 5 or 6 other votes in the form of their spouse and their kids. And obviously, I'm not saying Archie Bunker comes home and tells Edith and the kids how to vote, but households do tend to share values. And so these are millions of votes in the industrial heartland, if we still have one, who are up for grabs, and they're beginning to feel as though an administration that courted them has hurt them. And so there could well be a strike, and people are saying that strike could have significant consequences. I mean, it could cost billions of dollars to the economy in a relatively quick period of time, at a time, as we enter into the fall and there's signs of new COVID strains and potential threats of a lockdown. And you've got Tucker Carlson predicting World War III with Russia. And the idea that the economy is going to slow down amid international uncertainty and amid uncertainty about whether the economy will remain open given COVID, another round of COVID, it gives me the jitters. It makes me fear for the fall and for our economic security.
Well, yeah, and it seems like a microcosm of election system writ large, right? I mean, we've talked before about the push to subvert and do away with the Electoral College. So the fact seeing what they had a delegate system in place, I don't know if it's still in place. That's something that we can follow up on. But the fact,
if you've got any UAW listeners out there or folks with family members who are UAW employees, we'd love to hear from you. I'd like to know more about what's going on. This is the sort of story you don't get to see much or often in the mainstream press. As we say, it's in the New York Sun this morning. But when you're looking to determine what's going on on Main Street in America, where most of us live, it's stories like this that affect people's pocketbook that will give us an insight into what ordinary Americans are thinking. You don't need the editorial board of the New York Times to tell you what identity to prefer. You want ordinary people working with their hands to support families to tell what they prefer, what they need, and how are they voting and where are they going. So we're appealing to UAW members or those who know UAW members to give us some insight about what's going on in the union.
That's right. And just because I said that we were going to cover it in more detail this morning, I don't want to let us go without at least putting this back on the screen. I know that we're running short on time here, but if you have time, everybody listening, I do highly encourage you to go to to this story. It's on legal insurrection. It's written by Jane Coleman. We covered it at the very end of the stream yesterday, but it is an employment discrimination lawsuit brought against the City University of New York, and it emanates actually from one of the community colleges there in New York that is part of the CUNY system. Very interesting. If you're able to stomach reading the actual order. And really dive into the facts as presented and what the court did in looking to deny the defendant's motions to dismiss. So this lawsuit will go forward. The lawsuit will go forward. Sorry, I got a random call there. And we'll see.
Hi, this is AT&T. We want to increase your bill by 200% and offer you 50% of the service you had before. That's right. You can pay more and get less and talk to fewer people because our electronically screened monitors will divert you and waste infinite amounts of your time while you try to get simple answers to customer service, because we are the algorithm and we control you. Excuse me, Mike. That was my...
Yeah, and so there are two features of this. I mentioned yesterday that there was an EEOC investigation into this stuff, and there was also an independent consultant brought in for an investigation as well. And it appears that CUNY and the other defendants, not only did they get rid of the officer that oversees the responses to certain internal complaints and stuff like this, but they actually just disregarded a lot of, like, the independent consultant that they hired, right, to handle all of this stuff. And this emanates all the way back 2016, 2017, 2018. This lawsuit was not initiated until 2021. And the connection I'm making on the screen there is just that it looks as though this lawsuit, had it been higher profile, could have foretold the sort of valedictorian viral speech we saw from Fatima this year at CUNY's graduation and commencement ceremony, right, where there was all of the negative language around, white supremacy and everything else. So it seems as though the CUNY system has some real problems that it needs to dispense with, and I'm looking forward to continuing with this lawsuit. I just didn't want us to get out of here without at least putting that back on the screen, Norm.
No, I appreciate that. We try to fulfill our promises, but we don't always, because there's a lot going on in the world. Hey, if those of you who've been listening to Tucker Carlson on Twitter, here's a challenge: send him a note. He's putting together a network with a lot of new shows and whatnot. Tell him to give Law and Legitimacy a shot. We are truly independent voices trying to give you insight into what's going on in the law and in the world. And obviously, we're looking to expand our reach. We'd love a berth on Tucker's place. Tucker Carlson, if you're listening, give us a shot. All we really want is a perch, and we'll take it from there. Give us an opportunity, and we'll do well. Hey, Mike, what's this? I see we have an opening still.
We have one spot remaining. So we are doing a 12-person league this year for fantasy. And when all of the invitations went out this morning, we had one more. It was going to be a 10-person league. When all the invitations were being accumulated and being sent out this morning, realized that we had 11. And, I would rather just fill one more spot for an even 12 for us to proceed than to tell someone that they're out. So
I'll sit out if necessary. That's
first
all right.
come. No. You are not getting out of this, Norm. You keep.
I'll sit out if necessary.
Getting out of this.
The right thing.
No.
Well,
So
we don't get another person. We can't just say no to somebody. So I'll just have to sit out.
Well, look, first come, first serve. Email pattispodcast@gmail.com. We need one more person to enter the inaugural season of Ball and Legitimacy. So send an email, and we'll get all of that wrapped up and get the draft scheduled. We can't schedule that draft until we have a full league filled, and we've just expanded the fields to accommodate one more person. So we've got one more spot.
What's the name of your team going to be, Mike?
The Crystal Methodist. Come on, this.
I thought it would be the Boilermakers or something,
No. I think we've got Sidebar Society as one of the team names already. We've got Double Jeopardy team name. Anyway, I think we've got Taste the Dwayne Bowie. So yeah, we want some creative stuff, but we just need one more. Photography says, if we hit it big time with Tucker, do early LAL watchers get stock options? I don't know. Yeah, maybe. We don't want to get on the SEC's radar, do we?
You can have 90% of what I earn from this. You know, what are you going to do with nothing? You know,
Yeah.
so you know, we have fun though, and that's the point. And we bring you truthful information, at least as we see it each and every day. So I am filibustering here, hoping to talk my way into avoiding heading over to the Pretty Man courthouse today for the sentencing and Proud Boys cases. But something tells me duty calls, and I'm going to have to pack up my briefcase and head over to face the music in the courtroom of the Honorable Timothy J. Kelly as the United States of America seeks to persuade the judge that Joe Biggs should do 33 years in prison. Zach Brell should do 30 years in prison. We think justice requires otherwise. The judge will tell us what he thinks. Keep an eye on the papers and come back tomorrow morning. I'll report on what it was like to stand in the belly of the beast and sing for your client's freedom.
Indeed, we look forward to that. If you're here, please make sure you've liked the video that you're watching, whether you're on YouTube Live, whether you're on Rumble Video, or if you're over on X watching the live broadcast via Periscope. Follow us at LawPod Daily on X. And if you're on Rumble Video, make sure you're subscribed. If you're on YouTube, make sure you're subscribed. Hey, there's also nothing to say that you can't have an account on all of those platforms and do all three of those things. We're just not, demanding that you do it. Just do it on one. If you find us by audio after the fact, every day's stream is posted in audio-only form to Apple Podcasts, Spotify, Google Play, Overcast, Audible, and the rest of the podcast platforms, wherever you find podcasts. Please rate us 5 stars and leave a good comment. Or what, Norm?
Leave us alone.
Awesome.
All rise. The Honorable Norm Pattis is on his way out the door. See you tomorrow, folks.
See you tomorrow, Norm. We're getting good luck from Mari. All the best from photography. And indeed, we'll see you all back here tomorrow. Thank you, Norm.